Thank you very much. All the four speakers highlighted like how and why quantitative analysis of appellate authorities and tribunals are important. And they are important for various reasons. And I see specifically for three important reasons. One is for research and documentation, because unless the data is available or uploaded in respective websites or in their department, whatever online, it's very difficult to analyze what exactly is the impact of these tribunals, especially the process they follow. Second, it is also important for advocacy. Very often there are people who are interested to work in this field, but because of lack of data or information, there is hardly any scope or space to engage with the establishment. And when I say advocacy, ranging from the authorities to civil society groups and various other institutes which are interested to work in this area. Third, it is also important for capacity building. Capacity building of the authorities when you talk about the number of cases pending and why those cases are pending, and when you said the number of cases are resolved in December, number of cases are filed increasing in December, so there must be something one needs to engage with why all the three aspects are happening in a particular month. And this is also true in case of various other appellate authorities where applications are filed in a particular month and resolved in a particular month. So this will be useful to know what are those lacunas which are there in the authorities. Now, when I say this is important both for research, for all three reasons, research, advocacy, and capacity building, I'll just draw your attention to one recent data set. The government of India has come out with this new data set that is called environmental crime. Environmental crime data set was reported by the NCRB 2014. For the first time they came out. And you would be surprised to know in 2014 when they came out with this data set, they identified 5,846 crimes in India. Out of 5,846 crimes, only 50 crimes are related to industrial pollutions. And out of those 50 crimes, 42 crimes are in Maharashtra, and remaining 8 crimes are in 5 southern states. That means all those other 26 states, there was not a single environmental crime. And those other 26 states include those states where you have those critically polluted areas, 41 critically polluted areas. So this shows there is something, there is some serious problem when it comes to how we fit data in our recording system and how that goes to different authorities. Because out of those 5,846 cases, again, 77% of cases are registered under the Indian Forest Act and the Wildlife Protection Act. And only 50 cases are under Water Pollution and Prevention Act and all those 100 environmental rules and regulations. So this is very important when we get the data set, and people who are representing different appellate authorities and tribunals, we would urge them to bring this data set, upload in their respective websites, and it will help various institutes, even academic institutes like Azim Premji and TISS would be happy to engage with this data set and come out with different analysis which can be further discussed and debated. So with this, now I open this floor for discussion. We have 15 minutes for discussion. So you please introduce your name and the organization you represent, and also direct the question.
My good name is V. Munavenkatesh, Assistant Registrar Retired, Karnataka Appellate Tribunal, Bangalore. With my little memory, way back, that is a decade ago, one Mr. V.G. Gujran, commercial tax member, has written a historic order in the tribunal. Probably a department people who are, somebody is here, if they are aware, they can share with me. In his order, a beautiful order he has written. That is 220 pages he has written at length. For that, a district judge member has given a consent. By way, as he don't want to scratch his head. Because in the sales tax matters, most of the cases the commercial tax members, they man over the things. The reason is very simple. In a commercial tax cases, the schedules are there, calculations are there, and some other things are there. Assessing authority is there, first appellate authority is there. All these things, the district judge they don't want to go through all these things. A commercial tax member, he has come from the royal rank as an assistant commissioner, joint commissioner, deputy commissioner, and then he has become the additional commissioner of commercial tax, and sit over on the commercial tax member in Karnataka Appellate Tribunal. Really, he gives a very good shape to the case which he has handled in his lower ranking all along in the department. The department, at the fag end of his order, he writes.
Sir, we have very little time. Can you
Just a minute. Yeah. He writes a beautiful sentence. That is, appeal is allowed. That is, L&T versus State of Karnataka. L&T versus State of Karnataka. It involves 2 crores of tax. Fairly writes, appeal is allowed. Why? Because our house is not in order. That is, our house is.
So can you just brief your question?
What I'm telling.
No.
The house is not in order. The house is in not order means the department is not proper. He has sued the department, and he has passed the beautiful order. For that, a district judge member has given the consent. All right, okay.
Thank you very much. It's okay, we'll come back again.
Review has not been filed in that case. Why? The departmental people have not filed the review.
Okay.
That is the thing.
So any more? Yes, sir, please.
G.K. Upadhyay, President, Gujarat Cooperative Tribunal. In data, Right to Information Act is there. But even though common friendly users' data are not available in all the tribunals in India, the grouping and bunching and classification of codes are required for every matter and every subject if you want to achieve anything from tribunals. That's my question. Are we doing or not? We should see in our heart, and after that we can do help to our people.
Okay, sir has a question, please. We'll take 5 questions then.
Justice Reddy, a retired judge of the High Court of Karnataka. We've been doing a lot of this work, whatever you have done. But the real question is, when you meant backlog, take a situation. December 2016, a case is filed. Do you mean say it's a backlog in January of 2017? Critically try to analyze it. We can't go by these backlogs. Backlogs are what we think of in terms of hearing, when the cases come up for hearing at a particular date, and if it is not heard, that means when it has finally reached a stage which could constitute something like making of a judgment, nothing happens. And perhaps from that day you can call it a backlog. All these administrative works of trying to get records, trying to issue notices, serving it on parties, hearing interlocutory applications, but these things cannot constitute backlogs at all. There's yet another reason. Backlog is not just backlog as it is because it is pending for many, many years. Do you have the competent officers to man these organizations? Do you have people who have adequacies or inadequacies in their kind of work that they want to do? What's the kind of human resource development or done on this? What's the kind of training that you're giving to all these people? But these are many, many and more issues that arise. But it's nice to hear from all of you today that you have broken the ice. Somewhere you've started making creating a dent into understanding of what's happening in courts to make it more transparent. It's really good. I wish today's opening of this subject would lead to something comprehensive. You must have also known by now that the Supreme Court has constituted a national court management system. Now that is very comprehensive. As a member of that system, I had an occasion to deal with all these issues, which perhaps I will say when my next term comes up. But we've got to think in terms of policy decisions. Policy decisions are very important. Once we do that and keep these policies for the entire country, I don't think many things may arise. But as you rightly said, availability of data is the most important moot question, I would say. And if that is not done, well, nothing is done. Thank you.
We have the speaker.
My name is Mamdapur, Presiding Officer, Labour Courts, Bangalore. My question is, Mr. Sudhir, sir, you have done a lot of research in respect of filing of more cases, filing of less cases, and disposal of more cases. But we have to ascertain the reason why there is less filing. And one more thing is, 4,278 cases were disposed of in 2014 to 2016. And only 20% cases, 761 cases, appeals have been filed. Whether the disposal is on merits, in what way the cases were disposed of, whether reliefs were given or not, that way the research is very important. This is my suggestion, sir. Thank you.
We'll take the last question there for this first round. Yeah.
I'm Alok. I'm an advocate in Bangalore and a visiting fellow at the Vidhi Center for Legal Policy. I just had this question regarding Pratik and Surya's research on the IT-80. I just wanted a couple of clarifications based on what you have seen. One was, did you sort of look at how the listing process in the Bombay and Delhi differed? Because although there seems to be approximately the same number of cases, I've started some very preliminary research on the Supreme Court, some along the lines of what you have done. And my first big realization was that listing is a little idiosyncratic. There is no set rule or procedure. It is up to the presiding officer. So sometimes you have the absurdity of 200 cases listed before a judge, and there is no possibility of more than 15 being taken up. But they list 200 all the same to make it seem like either they're listing it. So I just wanted to know in what way the cases were listed. Was there a systematic way in which they ordered the cases, were cases ripe for hearing coming up? Just to make sense of the number, of the fact that there's a vast difference in, I'm not talking about a small 10-15% difference. Clearly, Bombay is able to dispose of twice the number of cases on a given day than Delhi. Would that have some linkage to the way in which they list cases? Thank you.
The answer to my KAT farmer officer's question is, his impression that always the department members took over the decisions in commercial tax. My answer is, as long as I was there for 3 years, not a single member overtook me. And so for not filing the review, this is the matter which you must ask the Commissioner of Commercial Tax. Must ask. I have sent about 25 judgments to the Commissioner of Commercial Tax, passing strictures against them. In one review petition, one of the member who was here, when he was taken back to legal cell, he has written such a aspersion on the KAT. I pass strictures and send the judgment to commissioner. When you are asking for the review, please pray it. Don't dictate or mandate. And secondly, my friend said that this revenue matter I told, as a judges we are least bothered about the revenue, but about the legality. Reddy structures matter which I have written, works contract. Everybody was quoting Gannon and Tankerle, rail development. Nobody was analyzing what it is. In that case, what happened, do you know? The assessing officer had given 10% land values exemption. The first appellate has given the 25%. The state has come in appeal before me. Then I said, after reading everything, I said that both orders were illegal. See, one thing I tell you, what has happened there is, the respondent said, sir, please reduce it to 15%. Then I said, no, I am not sitting here to modify or vary the illegal order. I said, I'll write the total judgment reappreciating the evidence as the first appellate court. I wrote that order, it was reversed, and do you know that 6 crore rupees was the amount which the assessee got back, which was illegally recovered. We are not bothered about who is getting legality, because High Court will see whether it is legal or not. These are the things. But administrative lapses takes place not because of us, because of that. And then there is, so for the question is, variation is filing. When I went there, very few sale tax matters were there. And after the VAT was introduced, the members were telling that, no, after VAT, there is very little litigations. We can't expect litigation to crop up, because if there is very hassle-free administration, less filing. That is because of that. Now I think after GST something more happened. And at that time, we 8 members were posted by the Honorable High Court. The 4 benches, tax benches were functioning, therefore it was reduced. So in my opinion, so for tax and this revenue bench are concerned, I think that cooperation and revenue is concerned, fast track benches could do well, because 93, 94 matters pending when I was there. Therefore, this may be, because as a fast track judge I worked for 6 years, and I disposed of 1,000 cases in Karwar. By the time I was transferred, only 6 cases were pending. So for these 2 branches, that could be possible, it could pondered over. Thank you.
So I have a small question. Small question.
So as far as the policy decisions that you spoke about, I think one important issue that was flagged by Sudhir is that we can look at the British tribunal reforms, and that has been extremely useful not only for the purposes of, just as Alok mentioned, about standardizing rules, but also about HR. Human resource is one of the most critical elements of any institution. And so it's important to think about a centralized institution at some level which manages it. So it's interesting, and I think this is something that we are going to discuss in the next panel, so I won't go into it, but it's important to take some kind of an understanding of how the British system has changed on tribunalization, and I think that has a lot of implications for India. Thank you.
So can I, just one second. I think the panelists are just going to respond briefly, and then I don't know what the moderator would like us to do. So I want to respond to 2 different parts that came up in the comments. One about data sources. And Mr. Upadhyay mentioned data sources, Justice Ramon Reddy mentioned data sources as well. And I think what's striking is that there is openness to making more data available, though I'm not sure how much of the High Court data is openly accessible, either on the website or otherwise. Having said that, I think there's a second problem, that every institution makes data available in its own way. I'm just astounded that every tribunal has its own format, and so does every High Court. So this is clearly not the way to go, and to the extent, and you spoke about NGT cases, so I've studied some of the NGT databases, and I think you'd agree that that doesn't look like the Karnataka Appellate Tribunal databases. So I think one of the first elements of national policy that we need, forget about how we serve notice and what adjournments we give. I think we should have a national policy on how data is stored in the Indian court and tribunal system. And it should be a single policy. there can be no variation on that basis. If we don't do this, we can make very little progress on much of the rest that we want to do. But I want to say a second thing about the point that Justice Rammohan Reddy made, which is that it can't be that we just take a month and say that this is pendency or this is delay and backlog. These are normative terms. They're not descriptive terms. And we must agree on what are the norms for pendency and backlog. You know, we might want to say that a cooperative case, 12 months is a norm for disposal. But in a sales tax case, it might be 18 months as a reasonable basis or something like that. This we need to work out. It needs to be sensitive to the details of each case, but we need to have an understanding of that. But what is striking is that if you didn't do that, you'd end up in a position like China, you know, and I just wanted to say this almost by anecdote and slightly trivial one, that China has the opposite of the KAT's graph figures. Because in China, in December, all the graphs point downwards. Because at the end of the year, there is not a single case pending. Even if the case was filed in November, there is great pressure on the court system to clear its dockets by the end of the year. And this pressure is top-down and clear. And all the courts show a downward graph. So it's almost like, I don't know what the inverse logic in the KAT might be, that all the courts show an upward graph, but it might be worth pondering. But I think the arbitrariness of just setting some absurd idea that everything should be cleared by December is clearly a mistake. We need to bring some sense to these categories of backlog and pendency, otherwise they don't really have any meaning. So let me just say that, I mean, there was a question by the president of the Labor Tribunal about disposal, and I think there was a partial answer that we tried to understand how many were merits-based disposals, but we did that on a small sample. So on the database, the 2014 database where we studied appeal rates, we didn't have the basis of decision, so because it was the full universe of cases. But you're right, that we should pay attention to on what was the decision in the case, and then whether it was appealable, and then constrict that number to get a realistic figure there. I take that point.
Yeah, briefly, sir.
I'll just take a couple of minutes to... So, Alok, we did not see any significant trend in how cases are listed. And as you are very well aware, there is so much discretion with the registry in how cases are listed. But one could say that the older cases get listed first. That is something that we can say is a thumb rule that for listing. But just to continue on that listing itself and the point that Justice Rammohan Reddy sir made on NCMS and a wonderful institution that got set up in 2012. In 2005, consequent to the Salem Advocates Bar Association ruling, there is this wonderful piece of legislation called Case Flow Management Rules, which are already in place across India. They are there, which says, this is how you segregate between stages. This is how you segregate between subject matter. This is how you list. The Karnataka Case Flow Management Rules are the best in the country. There is a debate. You could debate whether it applies to the KAT, but there is nothing that stops you from adopting it. And that actually gives you a limit on how many cases you can list per day, depending on the stage. Wonderful piece of legislation that all of us should use a lot more and implement in Indeed.
Thank you very much. We are sort of time, so we'll break now. And I thank all these panel members for raising several important questions. So we should give them a round of applause for their interesting observation. Thank you. Sorry, sir, we are already late. We'll come back again discuss. So we'll discuss that during tea.
statics also is considered. Your inference is bad. Otherwise, you have to give a retrospection of those things.
Sudhir will discuss.
That is very important. I feel so. It is very important as far as your inference is concerned, as far as the success rate or the rate of disposals, rate of pendency, all these things.
Okay, Sudhir will explain that during break time. So thank you very much. Now I request Nafisa Madam to felicitate all the speakers.